Good evening to the participants of the JCJ 2023 AP, which is going to be held on 7th January 2023 if it is not postponed. Participants, anyone can unmute and read what I posted on the screen?
Hindu Marriage Act,
1955.
Is it the correct way of writing Hindu Marriage Act 1955?
No, it's the Hindu Marriage Act.
Hindu Marriage Act.
No. It is the Hindu Marriage Act.
And M should be the capital letter.
Yes. M should be capital.
Yes, if you want to remove the comma, at that instance, you can write the Hindu Marriage Act of 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 1955. But don't write the Hindu Marriage Act, comma, of 1955. It is nothing but school buddy. School itself is buddy. Buddy is equal to school. Then both should not be present over there. That's what I want to say is. So now, without wasting the time, let us go to our studies concern. Yes, be ready. Andhra Pradesh Junior Civil Judge 2023 screening test to be held on 7th January 2023. Hindu Marriage Act, comma 1955 hyphen multiple choice questions. Ready? First question. The HMA Act applies to all forms of Hinduism. For example, to a person who is a number 1, Vairashaiva or a Lingayat. 2, follower of the Brahmo. 3, Prarthana or Arya Samaj. 4th, Parsi or Khoja. Now the option A, 1 plus 3 plus 4. Option B, 1 plus 2 plus 3. Option C, 1 plus 3 plus 4. Option D, 1 plus 2 plus 3 plus 4. Shoot the right answer among the ABCD.
Option B.
Option B. 1 plus 2 plus 3.
Yes, option B is the right. That is 1 plus 2 plus 3 is the right one. Because Parsi or Khoja is not there. So now the second question. In addition to the above first question, it also recognizes offshoots of the Hindu religion as specified in dash of the Indian Constitution. Option A, Article 41. Option B, Article 42. Option C, Article 43. Option D, Article 44. Shoot the right answer.
Article 41.
WRONG. Second option.
Option C, Article 43, sir.
WRONG.
Option B, sir.
WRONG. The right answer is
D, sir. D.
D, Article 44 of the Indian Constitution. That is the second question answer. Third question. The Act also applies to anyone who is a permanent resident in India who is not 1. Muslim, 2. Jew and Christian, 3. Parsis by religion, 4. Islam. Option A, 1 plus 2. Option B, 2 plus 3. Option C, 1 plus 2 plus 3. Option D, 1 plus 2 plus 3 plus 4.
Option D.
Option C, sir.
WRONG.
Option C. 1 plus 2 plus 3.
Yes, it's option C, 1 plus 2 plus 3, because Islam, there is no word of Islam there. Either the Muslim, Jew, Christian, Parsi by religion. And a supplementary question. Where the Parsis stay mostly in India? Yes, sir, Verunath, you should not give the answer.
I know, but I will not give.
I have already given the hint.
If they know from
where
if they know from where I am, then probably they must be knowing the answer.
Yes, because they know that you are practicing in Maharashtra. It is Bombay. And what do they what do they, what I say, pray? What is their church?
No, it is not called church.
Fire,
It is not called. It is called temple, fire temple.
fire temple. Yeah, you say fire temple.
It's called fire temple.
Yes, and when they die, they don't cremate, they don't bury.
They just threw them into that fire one, this thing. They don't bury, they don't fire them, they don't burn them. But only in one case recently, which has happened in Gujarat, where the High Court has given permission for a Parsi person to be for the fire aag lagane ke liye. That was only one case in the past.
Cremated.
Not cremated. Cremated is when you bury someone is called cremated.
When you burn on the fire, it is called cremation. When you bury
Okay, that is
below the earth, it is buried.
Yes.
They
So,
can
only
keep
in
the
one
dead
case-
body corpse on the grate of a well, and it is open to the vultures to eat it.
But only, I said, no, only in one case where the Parsi was where the High Court has allowed them to do the fire processes. Possessions.
Okay. No, it is their own choice, and nobody would make it out.
No, it's not choice. It is not choice. In Parsis, they strictly follow the rule of not burying or not giving fire also. But only during the COVID time, that was only one time where the family was given opportunity to do the thing instead of burying or putting them to vultures.
Okay. Now let us go fourth question. Although the act originally applied to Sikhs as well as the dash gives the Sikhs their own personal law related to marriage. A. Ranbir Singh Marriage Act. B. Anand Karz Marriage Act. C. Randhawa Singh Marriage Act. D. Ramdev Singh Marriage Act.
B. Anand Karj Marriage Act.
It is
For
the
Sikhs.
B. Anand Karz Marriage Act. They will follow. Personal law
But someone
related to
has
the marriage.
But in Bombay, one more thing. In Bombay High Court, the petition is filed for them also to become part of the Hindu Marriage Act.
Yes. Okay, now let us go to the fifth question. Anyone can unmute and read fifth question. Participants.
Section 5 of the Hindu Marriage Act specifies that conditions must be met for a marriage to be able to take place. If a ceremony takes place but the conditions are not met, the marriage is either void by or voidable. Option A, de facto. Option B, de jure. Option C, default. Option D, ab initio.
What is this dash here?
Option D, ab initio, sir.
WRONG. Second option.
Option B, de jure.
WRONG.
Option C, default.
It is a default. Either void by default. That is the right answer.
What is the difference between de facto and de jure?
Participants. Yeah, give the answer or I will give the answer. De facto means in the fact. De jure means it is in the law. That is the distinction between the de facto and de jure. Ab initio at the threshold. Like contract with a minor is ab initio void. Is it clear? Say yes.
Sir.
What is the landmark case law? We discussed this case law. What is the name of the case law? Can I give the facts of the case law? Can I give the name of the case law? A minor mortgaged the property Later on, the person who lent the money file a case. He says, I'm a minor. And minor will sit on the lap of a judge. Are you following me? Say yes. Mohiri Bibi versus Dharmdas Ghosh. That is a landmark case law regarding the minor's contract is void in ab initio. Yes, now the sixth question. A marriage may be declared void if it contravenes any of the following. Number one, either party is under the age. The bridegroom should be of 21 years of age and the bride of 18 years. 2. Either party is not a Hindu religion. Both the bridegroom and the bride should be the Hindu religion at the time of the marriage. C. Either party is already married. The act expressly prohibits the polygamy. A marriage can only be solemnized if neither the party nor having a living spouse at the time of the marriage. 4th, the parties are subindos or within the degree of prohibited relationship. Option A, 1 plus 2. Option B, 1 plus 2 plus 3. Option C, 1 plus 2 plus 1, 4. Option D, 1 plus 2 plus 3 plus 4.
Option D.
Option A, 1 plus 2, sir.
WRONG.
Option D.
Option D, sir.
WRONG. If you happen to see the third, they said the act expressly prohibits polygamy. Okay, good. A marriage can only solemnize if neither the party not having a living spouse at the time of the marriage. Here, has a living spouse, not having the living spouse, no. Having a living spouse at the time of the marriage. So the right answer is C, 1 plus 2 plus 4. Is it clear? I put the party not having, actually the party has a living spouse. Not having, no. Is it clear?
Yes, sir.
Good. 7th question. Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either the bride or the bridegroom. These rites and ceremonies include the Saptapadi and dash. A. Kureva. B. Krevua. C. Krujiva. D. Kreva. What is Saptapadi? What is meant by Saptapadi?
7 steps.
7
Around
steps.
the
Sapta means
sacrifice.
7. Padi means steps. And there is another word also there in other places. They follow it. The religious
Option
rites.
D.
Repeat.
Option D. Kriva.
It is option D. Kreva. Kreva. That is the right answer. So Saptapadi and Kreva, these are the two methods will be followed. 8th question. The husband after marriage has been found guilty of dash. These are the following. Number 1, rape. Number 2, sodomy. Number 3, incest. Number 4, bestiality. Option A, 1 plus 2. Option B, 1 plus 2 plus 3. Option C, 1 plus 2 plus 4. Option D, 1 plus 2 plus 3 plus 4.
Option C.
Option C, 1 plus 2 plus 4, sir.
I appreciate. That is the right answer. Good. 9th question. Anyone can unmute and read.
The wife was underage when she married and the marriage before attaining the age of 18 years. Option A, revoked. B. Rescission. C. Repudiates. D. Revert.
Shoot among the A, B, C, D.
Revoke. Option A.
WRONG.
Wrong.
Option C, sir. Repudiates.
It repudiates. Option C is the appropriate word there. So option C, repudiates, is the right word. The wife was underage when she married, and she repudiates the marriage before attaining the age of 18 years. In case if she does not do, that means she accepted it. 10th question. Anyone can unmute and read?
So, which other law can be applicable to that this thing?
Once he agreed and she will not repudiate, then it's deemed that is a marriage, even though it is a child marriage.
No, that comes under the POXO Act. Offense under the POXO Act.
Mm-hmm.
It's a criminal offense. Even if a Muslim, if she attains a puberty age and she is married by 15 or 16 years age, then also it is a crime under the POXO Act. Even the personal law may say it is allowed, but the POXO law says very clearly it is a crime.
Okay.
So the person, husband, whoever, he will be charged under the POXO Act.
Yeah, they want to harmonize it there.
Yes.
Okay.
Even the personal law says it is allowed, but the other act, the POXO Act, overrules the personal law in this matter.
Yes, because justice should be there. Justice to be done, and justice seems to be done. So in that view, they can take it. Like a Muslim can apply for the maintenance under the CRPC 125 also.
Yes, yes.
It is option given to the party to apply for the getting the benefit.
Which
So
is a
that's the
famous
question.
case law
Yes.
in Muslims for Muslim maintenance.
Saira Bano case.
Correct,
Shah
correct.
Bano case.
The latest
Shah
case
Bano.
law
Saira
is
Bano.
where the triple talaq is biddat.
Yes, that is illegal, actually, if you ask me.
Yeah, it's a
But anyway,
biddat,
I
we'll
don't-
say. What is the name of the case law? Sayara Banu. That case law name is. 11th question. Which is the odd man out or a false statement? A. The most significant institution in human society is marriage. B. The foundation of human civilization has come into the photo because of marriage. C. New social ties and reciprocal rights between the spouses are created through the marriage. D. One of the most profound and intricate human partnership is marriage. Which one is odd man out? Among the four
Option
statements.
B.
False.
Option B. The form.
Suppose if I agree option B is the wrong answer. What would be the right wording there? The foundation of the human civilization has come into the photo, no picture. It is not the photo in the picture because of marriage. So I removed the picture and I put the photo. Are you following me? So the appropriate word should be there, otherwise it is odd man out. 12th question. The laws governing the Hindu marriage, dash, maintenance and guardianship are included in the Hindu Marriage Act 1955, and which is odd man out, means not connected to it. A. Imposition of the conjugal rights. B. Judicial separation. C. Divorce. D. Annulment of marriage.
Option A, sir.
If I agree, the option A is the right answer. What would be the right wording?
Annulment of marriage. Option D.
No, I agreed.
Restitution of
I agreed A is the right answer.
option.
But
Restitution of conjugal rights.
restitution of conjugal rights. It is not the imposition of the conjugal rights. It is the restitution of the conjugal rights. So that is the odd man out there. And the 13th question. Match the following chapters in part A and its application or explanation in part B. Part A, chapter 2, chapter 3, chapter 4, chapter 5. Part B, jurisdiction and procedure, nullity of marriage and divorce, restitution of conjugal rights and judicial separation, and Hindu marriage. Of course, small a, small b, small c, small d here. Now, options. Option A, 1B, 2C, 3A, 4D. Option B, 1D, 2B, 3C, 4A. Option C, 1D, 2C, 3B, 4A. Option D, 1B, 2C, 3D, 4A. Which is the
Option B, sir.
C.
B, sir.
Option
CA.
Option C.
B, sir.
read the full.
Option C, 1D, 2C, 3B, 4A.
Option B, sir. DBCA.
Sridevi is right. It is option C, 1D, 2C, 3B, 4A. Now you can see the feedback. Chapter 2, Hindu marriage. Chapter 3, restitution of conjugal rights and judicial separation. Chapter 4, nullity of the marriage and divorce. Chapter 5, jurisdiction and procedure. So the right answer is C, 1D, 2C, 3B, 4A. 14th question. According to Dash of Hindu Marriage Act of 1955, the bridegroom must be at least 21 years old and the bride must be at least 18 years old when they get married. Which section says? Section 5.1, class 1, section 5, class 2, section 5, class 3, section 5, class 4.
Option C.
Option C, sir. 5 class 3.
Section 5,
Yes?
3, sir.
Option C.
Option C is the right answer.
Section 5, 3. C, sir. C.
Yes, option C is the right answer. That is section 5, class 3. 15th question. In the recent case of Dash, that is a 2021, the Supreme Court noted that the wife was making accusations that were harming the husband's reputation and job, which would undoubtedly qualify as a mental cruelty. In which case law it is decided? A. Amarjit Singh versus Union of India. B. Lily Thomas versus Union of India. C. Ravana Siddhappa versus Mallikarjun. D. Joydeep Majumdar versus Bharti Jaiswal.
Option B, Lily Thomas versus
Sir.
Union of India.
WRONG. Second option. All the 5 case laws are landmark case laws in Hindu law. Each and every case law, please read it. It may be useful. It may be asked in any other form. So here, the right answer is D. Joydeep Majumdar versus Bharti Jaiswal. In that case law, the Supreme Court noted that the wife was making accusations that were harming the husband's reputation and job, which undoubtedly qualifies as a mental cruelty. So these are the things which I prepared today, 15. And the other part of is concerned. I am also ready with that other part. Just me check it and see. So this is the other part which I want to share with you, but the voice should be heard. Then I should have to say share the computer audio. Then I say share. Then I can play. Yes, you could hear me now.
They divided into the two. Okay. Come to the point of today's All India Bar examination in law, with the family law part 1 and family law 2 is the Muslim law that we will read it tomorrow. Yes, so the first question is, what are covered under the Purusharthas? Number 1, Dharma, 2, Artha, 3, Kama, and D, all of the above. Yes. All of the above, sir. All of the above is the right answer for that one. Feedback is this is also come under the. There are also Purushashta, Moksha also there. Liberation, freedom from the cycle of death and rebirth of salvation. That is also be there because the four options are there. That's why you have to write the all of the above. Yes, the second question is the majority of the Hindus are lacto-vegetarian, which means what is meant by lacto-vegetarians? Avoiding meat, avoiding beef. Yes.
Avoiding beef.
Here the lactogen, when you say meat, doesn't even meat, the beef will not come under the meat. All of the above, sir. All of the above is the answer because when you say meat, it comes everything beef. Of course, mutton means that is different. That is the goat mutton is a mutton. Yeah, and the cow or bull is the beef. Of course, I have posted you in the group WhatsApp one time the different types of the mutton, the flesh of the different animals and birds. Okay, come to the next point is that is the third question is under old Hindu law, a Hindu male was not under the obligation to maintain the following person. So a Hindu male and the old law is not, I say not. When I say not means generally his wife is not married.
And married daughter.
Yes, that is the answer. That is the C is the answer. That is the married sons and married daughter is there. But actually the unmarried sons and unmarried daughters are there. But I changed to the married sons and married daughter so as to make it to not. Yes, other person 3R will be covered under under them. That is his wife and unmarried daughters, illegitimate sons, and aged parents also. Yes, sir. Fourth question. Which section is of the Hindu Marriage Act and tradition? No Hindu marriage is binding and complete before the seventh step of the Saptapadi ritual in presence of the fire by the bride and the bridegroom together. Which section says? Yes, sir. Section 5, 6, 7, 8. The answer is any one of the above. Sir, is the section 7 says the Saptapadi. Section 7. సప్త 7 సముద్రాలు దాటి సప్త 7 సముద్రాలు అని చెప్పచ్చా అండి? ఎస్ వై సప్త అంటేనే 7 కదండి, మరి సప్త 7 ఏంటి? స్కూల్ పడింది ఇక. Okay, come to the point. In which decided case law that it would be fair to provide wife with the 25% of the husband's net salary as a maintenance. ఏ కేసులలో చెప్పిందండి 25% మెయింటెనెన్స్ ఇవ్వాల వైఫ్ కి హస్బెండ్ సాలరీలో. ఏ కేసులలో డిసైడ్ అయింది? రాణి సేతి వర్సెస్ సునీల్ సేతి ఆర్ యశ్పాల్ సింగ్ ఠాకూర్ వర్సెస్ SMT, that శ్రీమతి అంజనా రాయపూత్ ఆర్ డాక్టర్ కుల్భూషణ్ వర్సెస్ రాజ్కుమారి and others are all of the above. Answer is it is the Dr. Kulbhushan versus Rajkumari and others. Because I saw the All India Bar Examination model paper, there I found they have given the what is gist and the below they have given the decided cases, reported cases. So with that view only that I prepared this question number 5. Your feedback. Delhi court recently issued the case of the Rani Seth versus Sunil Sethi, ordered the wife means respondent to pay the maintenance to her husband. Petitioner, rupees 20,000 and rupees 20,000 and 10,000 at execution expenses. Further, a Zen car was ordered to be given for the use of the petitioner. So why I have given this case law means it is not only the wife, the husband should have to give the maintenance to the wife. The wife also should have to give the maintenance to the husband when the husband is not a earning member. So that is the point of the thing. The subsidiary question. Yashpal Singh versus Thakur. Yashpal Singh Thakur versus SMT Anjana Rajput, where the husband incapacitated himself. Because not to end himself, he incapacitated himself by stopping to run a auto rickshaw. Hence, where a person intentionally incapacitates himself, he loses the opportunity to file an application for seeking the maintenance. At the time, he will be failed to get the maintenance because he intentionally incapacitated to maintain the auto rickshaw. At the time, he will not get the thing. Because sometimes the subsidiary question is they may ask in that way also. And which case law says where a person himself incapacitated to get the maintenance, then you have to say the Yashpal Singh Thakur versus Srimati Anjana Rajput. That was the case law, because this is a subsidiary question. Yes, comes to the next. Which section of the Hindu Marriage Act 1955 spells down that when one's consent is not obtained, the marriage is considered void? So when the consent is not obtained over there, the marriage is void. Yes.
Section 11.
It's the C is the C, section 12. In the section C, the C answer is
Section 11, sir.
the consent should be necessary. Next question. Polygamy became illegal in India in? Yes.
After enactment of the Act, sir, 1955.
It is 1956. It is become illegal. Yes. What is meant by polygamy? Subsidiary question.
One husband, many wives.
Two wives, sir.
Why two wives? Two are more than two. Two are more than two. Yes. What is the polygamy opposite? More than two.
Monogamy.
Polygamy opposite. Monogamy is there, okay. But suppose you would only one wife, many husbands. Polyandry, yes. Where the polyandry is subsidiary question. Where the polyandry is mostly followed? Nepal, Bhutan, and there is a South India. There is a one community is there, which I am going to ask you in this one. There is a Toda. Yes. At present, the bridegroom has to complete dash years of the age, and the bride has to complete dash years of the age at the time of their wedding. Pardon?
21 and 18.
Very good. Appreciate. Good. The ninth question is, the couple should not be in a dash relationship unless their custom permits them to get married. What is the dash?
Prohibited.
Not be in a prohibited is the answer, or children of the same parents is the answer, or uterine sister is the answer. All of the above. Because all comes under the prohibited degree. Are you following me? Okay. Then the Griya Sutra classifies marriage into different forms, which not one among them. I said not one among them. Arshita. No, Arshita. Because Arsha is the right word, but I made Arshita. Ara Prajapatya, Gandharva, Rakshasa, Pachacha. These are all the different type of the Griha Sutras marriage at the time. But not is Arshita, because actually Arsha. Then I made the Arshita. So Hindu worship is one supreme being called. Who is the supreme? Hindu worship. But I saw Brahma is given the answer. I saw the answer, Brahma is there. Anyway, that subject to the correction. Yes, polyandry is still practiced in which minority tribe sect in South India? A, B, C, D, Chapandi. It is a C, T-O-D-A. It is a C, only Toda. Feedback, polyandry in India still exists among the minorities and also in the Bhutan and the northern part of the Nepal. Polyandry has been practiced in several parts of India and such as Rajasthan, Ladakh and Janskar in Jansar Bawa region in the Uttarakhand among the Toda of South India. A subsidiary question. What is concubine? And who is the para?
Who are living in relation without any type of marriage.
Who? Man or woman?
Women.
Then what about that man?
Adultery also.
Of
Adultery.
course, suppose the wife is having, in addition to the husband, and he is having another man. Paramore, yes. Yes. Not wife exactly. Keep. Yes, now the subsidiary question. Where the paramour, what is used over there in the one of the case law, where the last jury case law, and where the pilot is there and he killed, it is the amount to the provocation. What is the name of the case?
Kavas Manik Nanavath versus State of Maharashtra.
Yes, that is the right case law. What is the movie where the Akshay Kumar is the hero?
Yes, sir.
What is the movie name?
I just remember Nanavath is only movie name, sir.
No, there is a movie,
Rustum.
either pilot or something. The movie name is there. Where the Akshay Kumar is the hero.
It's Rustum.
Is depending.
Actually, a web series, sir.
Yeah. No, it's a movie is there. Yeah. Anyway, come to the point. Hindu joint family decides to do partition, then it is joint status of the family comes to begin and end, to progress, to develop. Which one is the right answer? To end. It is an end. Is the right answer. Not to begin, not to progress, not to develop. Yes, the next question is, it is pertinent to note that no partition is possible if there is only dash co-partners in a joint family. An odd number of, an even number of, a single, a zero. A single. It is a single, not odd number, not even number, not a zero. It is a single. There is no question of dividing in the co-partner in the joint family. Each of the co-partner has an equal share of the property of the joint Hindu family, and each of them reserves dash title in the property. Is a natural title, fundamental title, an inherent title is the right answer, not a traditional title. Yes, it's an inherent title in the property. 16. The court stated that when the elder brother had purchased the property from his personal funds, it cannot be subject to the partition and included in the joint family. And the instance of the younger brother was observed in the case of, see, I have given the 4 cases here. That is Jingulaya Subramaniam Naidu versus Jingulaya Venkatesulu Naidu. Then the Prafulla Kumar Mahapatra versus Joykanta Krishna Mahapatra, and Mrityunjaya Mahapatra versus Prana Krishna Mahapatra, then Pachi Krishna versus Kumaran. These are the 4 cases. The answer is Mrityunjaya Mahapatra versus Prana Krishna Mahapatra is the right answer for this question. I will give you the feedback. In the Pachi Krishnama and the Pachi Krishnama versus Kumaran, the court stated that daughter claimed his share as equal to the son in partition of the joint family property. But she failed to prove her custom, which says that the daughter can get an equal share as to the son. After the amendment of the 2005, the Hindu Section Act, which section says, yes, this is a subsidiary question. There is the amendment to the Hindu Succession Act where even a daughter also equal share with the son. What is that section?
25 years, sir.
Section 6. It gave the power of the daughter has the right to ask for the partition and can claim an equal share as to son in the partition of the joint family. It is a subsidiary question. Suppose the daughter also gets the joint family, the equal share would be there in which case law, then you can say it is the Pachi Krishnama versus Kamaran. That is the case law. Yes, Narayana Ben Firoz Khan Pathan versus Narsimbanu Firoz Khan Pathan versus Patel Shanta Ben Vikshabhai and others in this Gujarat court as on 26/9/2007 held. What is held in this case law? What is the principle involved in this case law? This Pathan case law. Here I have given that the Hindu daughter after a marriage to a Muslim guy does not lose her right to inherit the property under the Hindu Succession Act. Suppose if the daughter married to another Muslim guy, or yes.
That a Hindu daughter after marrying inherit under the Hindu Succession Act.
That is the answer.
Yes.
No.
She does not lose her rights, sir.
She does not lose her rights. Even though he married to the Muslim guy.
Not only Muslim, but any other.
Any other. Why Muslim? Any other. Yes, both A and B, no. None of the above, no. Right answer is A. That is bit A. Yes. A reopening of the partition cannot be done under the following options. A reopening of the partition cannot be done under the following option. Mistake, fraud, qualified co-partner, a child in womb. Actually, the disqualified co-partner is there, but I made the disqualified to the qualified co-partner, then automatically it becomes a not.
Fraud.
Qualified co-partner answer. I say cannot. Cannot means qualified co-partner. Unqualified means can. So mistake, we can reopen it. Fraud, we can reopen it. Child in womb, we can reopen it. But qualified co-partner, we cannot reopen the partition. Yes, Dayabhaga, Mitakshara. These are the only two schools generally. But the Madras School of Law are of the opinion that when a member of a joint family is once separated, they can only be reunited with, yes, if once separated, it can be reunited with father, brother, paternal uncle, or all of the above.
All of them.
Answer is all of the above, because father also, brother is also paternal uncle, they can be reopened. Of course, there is only two schools are there, Dayabhaga and Mitakshara. What is that? It is a subsidiary question. What is the difference between the Dayabhaga and the Mitakshara? Yes?
Daga is applied to Shara is for the whole India.
That right, Madras and others.
See, where is the steps and batch division would be there in the inheritance? Strips and batches. Inheritance would be there. But the
Share of
strips-
property is also different.
Yes, there comes over there. Because I do have the question. I do have the question like that. Yes. Divorce can be sought by husband or wife on certain grounds, including A, B, C, D. Here I have given it answer also, but I want to hide it.
Option
Continuous period of the desertion of the 2 or more years and the conversion of religion other than the Hindu, mental abnormality, mental diseases and leprosy, all of the above. But all of the above, leprosy is now removed. Leprosy is no more now ground. Leprosy is removed over there. Feedback is leprosy is removed. In the Personal Law Amendment Act of 2019, removed the leprosy as a ground for the divorce in 5 personal laws. What are the 5 personal laws? Of course, there are many things are there.
Muslim law, Christian law,
Yes.
Parsis,
Because they say 5. Subsidiary question, they will ask in this way also. What are the 5 where this leprosy is removed in the personal laws? Okay, please check it because they may ask in that way also. Now come to the next point is, of course, leprosy is no more now a ground for the getting the divorce. No? Okay, now dissolution of marriage. Now Ram Charan Sharma versus Suresh Chandra Pathan and others case law deals about. Deal చేస్తుందండి Ram Charan Sharma versus Suresh Chandra Pathak and others case law deals about partition filed by the widow, partition filed by a minor, oral partition, or partition filed by joint Hindu family.
Partition filed by minor.
No. It is a oral partition. This case law is a very famous case law. It deals about the oral partition. So partition, the other things also there. We can make it partition by widow is there, partition by minor is there, partition by joint Hindu family is also there. But it actually deals with the oral partition. Yes. Dayabhaga school dash follow any concept like co-personary.
does not follow any.
It does not follow any concept like co-personary. Dayabhaga doesn't follow about the co-personary. Yes, that is the answer. Removal of leprosy by the above amendment act. How many acts changes are brought out? 5. What are they? ఇక్కడ చదవండి ఇప్పుడు. Yes. Read.
That 1869, the Dissolution of Muslim Marriage Act 1939, the Special Marriage Act 1954, the Hindu Marriage Act 1955, the Hindu Adoption Maintenance Act 1956.
Yes, they ask the question also, where the leprosy is dash, then you have to mention, or they ask like this, in any form, they may ask you, that's why that you should have to remember that 5 acts where the leprosy is changed. In these acts, yes. Then section 7, chapter A, amendment to Hindu Marriage Act was done, 1968 to the Hindu Marriage Act 1955. What type of the marriage was included in the section 7A? ఒక type of the marriage include చేసింది section 7 capital A లో. అక్కడ ABCD రాశాను మొత్తం. కానీ it's only spelling. Please check the spelling and give me the right answer. Yes? Anyone? Sarasa, how do you pronounce it? At least tell me. The right answer is Surya Maria Tai. Surya Maria Tai. See. Surya, S-U-Y-A. Maria. Mari, M-A-R-E-Y-A. T-H-A-I. The C. Surya Mari Tai is the new type of the marriage is inserted in the section 7A. So, you should be very much careful regarding the spelling also. So, the 7A inserted by the Tamil Nadu government in 1968 provided the particular kind of the marriage that is the Suya Mariata, a self-respect marriages. Among two Hindus in the year 1968, it became an act by introduction of the section 7A, amendment to the Hindu Marriage Act. They may ask the subsidiary question, in which year also they mention, and which type of the marriage also inserted under the 7 capital A. Yeah. Which one is not? I say not. The ground for the divorce under the Hindu Marriage Act. I say not.
Yeah. Both B and C. Both B and C.
B, sir. B, both B and C.
Adultery is a ground, okay. And
Taking bath 3 times and changing clothes 3 times a day.
B and C is the right answer. The B and C is the means D is the right answer. Because when you get a desertion, you should.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।